unconstitutional and invalid. The application was brought forward by the Democratic Alliance after government announced its decision to withdraw from the ICC last year, following a dispute in 2015 over a visit by the Sudanese President Omar al-Bashir.
In the present case, that an order of suspension is not appropriate, nor is an order limiting the retrospectivity of the effect of the declaration of invalidity, given the inherent urgency of the matter. It's our conclusion. In any event, government respondents did not make out a case for such an order, although the Council on their behalf faintly suggested that we should consider suspension. As a result, the order of invalidity is with retrospective effect, and no order of suspension would be made. Having found that the notice of withdrawal is invalid for the reasons discussed in this judgment, a declaratory order to that effect must be made. But to constitute an effective remedy, that declaration should be accompanied by an order directing government respondents to revoke the notice of withdrawal. Lastly, we have applied our mind to the question of cause as we must. The general principle as far as that is concerned in constitutional litigation were laid down by the Constitutional Court in affordable medicines and buy-watch cases. Relevant to the present case is that in constitutional litigation between a private party and the state, if the private party is successful, it should have its costs paid by the state, while if unsuccessful, each party should pay its own case. The DA has been successful. It is entitled to the costs from the government respondents. However, the costs of 3 counsel are not warranted. Costs for 2 should suffice. With regard to CASAC, we are of the view that it is not entitled to costs. It waited until late to file the application for intervention. Unlike the DA, it elected to file an application for direct access to the Constitutional Court only, and not in this court. When that application was dismissed, it found itself not being party to this application, resulting in an application for intervention on an urgent basis. With regard to the supporting respondents, SALC, CHR, and HSF, they are ordinarily, as respondents, not entitled to costs from other respondents, in this regard, government respondents. Therefore, no order of costs as between the supporting respondents and the government respondents should be made. In the result, the following order is made. 1. The notice of withdrawal from the Rome Statute of the International Criminal Court, signed by the first respondent, the Minister of International Relations and Cooperation, on 19 October 2016, without prior parliamentary approval, is unconstitutional and invalid. 2. The Cabinet decision to deliver the notice of withdrawal to the United Nations Secretary General without prior parliamentary approval is unconstitutional and invalid. 3. The first, second, and third respondents, the Minister of International Relations and Cooperation, the Minister of Justice and Correctional Services, and the President of the Republic of South Africa are ordered to forthwith revoke the notice of withdrawal referred to in paragraph 1 above. 4. The first, second, and third respondents are ordered to pay the applicant's costs, including costs consequent upon the employment of 2 counsel. 5. There is no order of costs as between the intervening applicant, the first, second, third, sixth, and the 10th respondents.